Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Hey there, welcome back to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion. For decades, Tom has guided families through complex estate planning decisions with wisdom, care, and legal precision. My name is Kevin Rosenquist, and today we are talking about special needs planning. Tom, welcome back.
Good to be back. So we got a nice topic today.
Yeah, last time you had a story for us about a special needs adult kind of got taken advantage of a little bit in the aftermath of the parent's death. So first, but let's talk about the special needs consideration. There are many children who have various disabilities out there. Obviously, what kind of special planning considerations should be made to address those needs and as well as the issues that they'll face throughout their lives?
Well, traditionally, we have two issues. One is who's going to be able to make personal, financial, and medical decisions on their behalf. Second is we need what sort of financial provisions can we make for them? And I say that a little bit broadly because many people tend to rubber stamp these decisions. When it comes to individuals who have various developmental disabilities, the answer to the first concern is, well, they need to get a guardianship. And we'll talk briefly about why that may or may not be the right option. And then a lot of times when it comes to taking care of assets, people say, well, let's get a special needs trust. And most of the time that seems to be the right answer, but sometimes it's not necessary. So, as to the first one, anybody, once they turn the age of 18, is presumed to be mentally competent. So any of us, if we clearly are competent, should sign 3 documents: a will, as an advance directive, and advance medical directive, and a power of attorney. When many individuals with disabilities hit the age of 18, someone, mostly well-meaning, says, you need to go out and make sure they get a guardianship. Well, the guardianship first is having someone's child declared as mentally incapacitated, which may be necessary, but oftentimes can be avoided. And it's also a relatively costly procedure. When you take a look at capacity, it's kind of contextual. I always tell people it's like a scale like 0 to 100. Like, hopefully, you and I are closer to 90 to 100, maybe for me 85 or 80. But there's some people that have severe cognitive issues that are, say, 10, 20, especially near the end of Alzheimer's. Many of us probably fall into 3 ranges. So one is 60, let's say you're below 60. You're 60 and above, you can handle your own personal and financial affairs. And I've also said 40, you're really, kind of unable to do much of anything. But interestingly enough, in my opinion, although I wouldn't let you handle your personal, medical, and financial affairs if you score less than 60, using my analysis or analogy, if you have more than a 40, you still probably have the capacity to be able to execute a healthcare directive and a financial power of attorney. So, because what those documents are saying is that you may not know how to handle these things yourself, but you do have the capacity to know that you want to appoint somebody to do these things for you. Typically when it's a child and they hit 18 years of age, they're going to appoint maybe their mother or their father or both to take care of them, or as they get older, maybe a sibling or a close friend. So I often tell people, before you go out and get the guardianship done, let's see what we can do to ensure that our child has some ability to make that decision. Now, there's one caveat to that, and that is the person may be competent to sign, but a guardianship may still be necessary because in that 40 to 60 range, you can go either way. So I had a case some years back, about 20 years ago, where a young man had a particular condition, and we initially had him execute a healthcare directive and power of attorney. However, he would go into some rages, some fits, and be non-compliant, and especially had some medical issues that needed attention and decisions made that were rational. Under the healthcare directive, it's voluntary, and the key is that that child was able to say, all right, Mom, you're my medical agent, but the way the law says is that she can only do something if he's incapacitated or to the extent that he would allow her. So under a guardianship, that ability is passed to the guardian. The guardian makes a decision because you're incapacitated. You no longer have that right. So it was kind of sad that we had to do that. We've had to do that a couple of times. But most often, when you can let people not just save the money, but really respect the dignity of their child, it means a lot. So now the other one comes down to is the special needs trusts. A lot of times people are concerned about their children needing needs-based government benefits. However, one thing I've done over the years is a similar thing, but many of my colleagues have done as well, is a support trust. And really, the key is when you set up a support trust, you're saying that my trustee can take care of my child and do whatever they want for their health, education, maintenance, support, and you can put some provisions about how you want to see the money spent for things like vacations, etc. Under a special needs trust, you have to basically be clear that it's just supposed to supplement, not replace needs-based government benefits, SSI and Medicaid. We can get into what those benefits and those programs are. However, I found there are occasions when it doesn't make sense. So basically, health support and maintenance is not considered part of what you get under a special needs trust. So under special needs trust, you're supposed to derive your health support and maintenance first from your monthly check from the government plus the Medicaid benefits. So over the years, for example, I had a gentleman that had 2 children with special needs. They both were on the autism spectrum. They're high function. I mean, they graduated from local high school. I mean, they're limited extremely as to what they can do. However, the father, who was a single father, had $18 million. And basically, when he passed away, everything was going to be divided 3 ways. So each of the 2 children with disabilities would get $6 million each. They were both high functioning, had no greater medical needs, not much more than you or I would have. So it didn't make a lot of sense to have a restrictive trust like that around. And we figured that for $6 million, you can buy a lot of insurance for that. Mm-hmm. So I'd usually try to say before you put someone into a special needs trust, you should have something that looks at the amount of money going in, cross-reference with the functionality or the abilities that the individual has.
I know for certain situations, there's government programs for special needs individuals as well. How does those government programs work together with an estate plan in this situation?
Okay. Well, let's say, for example, I have a child that has Down syndrome, and they're joy in my life, but I know that when I pass on, that they're not going to be able to take care of themselves. So I want to leave money behind for them. And it's really going to leave it behind in a trust, not outright, because my child, whom I love very much, if I left money to him, regardless of any concerns I might have about benefits, oftentimes, or they attract predators and the money gets taken away. So there are 2 schools or 2 categories of government benefits. One is Social Security disability or Social Security disability insurance. And the other is the Supplemental Security Income or SSI tract. On both tracks, you have to show that the individual is incapable of, substantial, meaningful or gainful employment. So it means you can work a tad, but not much, not enough to really subsist. The second criteria for each of these tracks differs. Under the Social Security disability tract, if you have paid into the system, i.e. the Social Security system, for 10 years or 40 calendar quarters, then you're eligible for SSD. So let's say it's not a case of someone with a disability that's, let's say it's somebody that's an adult. They've been working for 40 years, but they got in a car accident, and that's their ability to continue working. But they were working for 20 years beforehand. They are allowed to get a Social Security disability. And that usually works out well because the amount's typically higher than what you get under SSI. And on top of that, after 2 years, you often get Medicare automatically. The important thing about that tract is that it doesn't matter what your assets or resources can be, unlike the other tract where your assets and resources are taken a look at. So, for example, if I was, my dad used to say, tongue in cheek, if Bill Gates was unable to work and was classified as disabled that he could get SSD and Medicare. And although we can't foresee that happening, it is true that if something would happen to you and I after working for many, many years, if somebody left, if we got on SSD and Medicare, and years from now somebody gave us an inheritance of a couple $100,000, those programs are still protected. But the big ones, and this affects many individuals who become disabled later in life or were born with disabilities, they typically will get onto needs-based benefits, and that's supplemental security income, in which there's basically, you have an income cap, which is relatively modest in the hundreds of dollars. And then you can't have more than what's called $2,000 of countable assets or countable resources in your names. And countable is just what it sounds like. A countable asset is an asset that the government's going to count prior to determining whether you're eligible for needs-based benefits. And a non-countable one is one that they don't look at. So they don't look at personal effects for anybody. If you're married, they won't look at the house as long as the healthy spouse continues to live in there. But under the SSI track, you automatically get Medicaid. But if you want to say somebody dies and they get inheritance for a couple $100,000, they lose those benefits. So the way to avoid that is to set up a trust. Most of the times it is a special needs trust.
Okay, that was going to be my next question. Like, what is the best way to, be able to balance the government programs with the estate plan? So the special needs trust is pretty much what you would recommend in that situation?
Most of the time. So the only exception I have, and I do see where the need for the benefits is either slight, or is it because in the case I gave you, the amount of money that's going to be left behind is so substantial that the income alone would be able to buy private insurance, which would eliminate the need for needs-based benefits. But really, 90% of the time when we're dealing with individuals, they do need a special needs trust. And so when they come in, the trust has to meet certain criteria. First, once it's funded or upon death, it has to become irrevocable. Then on top of that, it has to be clear that it's to supplement rather than replace needs-based benefits. And then it has to define the benefits that are available. It also has to state that the person who is going to be receiving the benefits cannot be the trustee. They cannot have a power to demand. I mean, the trust is for their benefit, but they can't, demand the trustee give them X or Y. Typically, distributions should be made to third-party vendors. You're generally not supposed to give out cash. The idea being, if you can give out a few dollars in cash, the government will say you can give it all out in cash. And the other is that the trustee should have absolute discretion. So it's something that does not give rights, but it's important to make you appoint a compassionate trustee to take care of the child. Now, the reason why it may sound silly that I said that the beneficiary can't be the trustee is that we often think disability, that means they have a cognitive issue. But there are many people that have a physical issue, somebody that has been in an accident and they're paralyzed. I mean, their mind can be sharp as a proverbial tack, but their ability to function because of the effects of the paralysis means they can't work anymore. On the other hand, and their assets are low that they would need the benefits. Intellectually, they could handle the trust, but they're just disqualified from doing that. Hope that's a good answer.
Yeah, no, that is a good answer. And forgive me if you mentioned this earlier. I wanted to make sure I asked this, but a normal trust, well, not a special needs trust. The other trusts that we've talked about in the past, you put lots of different stuff in there: money, houses, property, whatever. Is that the same with a special needs trust, or is it different?
Well, actually, so your will or living trust would direct assets to go into the special needs trust. And it's a great point, Kevin, because a special needs trust is it's like a person, it's a separate entity. It can own stocks, bonds, mutual funds, real estate. So it doesn't have to all be in quote unquote cash. One thing I do think it's worth mentioning is that, and we should make sure we get both of these before we zip out today, is who should be the trustee, and the second is is how in what document should the special needs trust appear. So let me start with the second one. A lot of times I've seen occasions where people will have a special needs trust put in their will. So I have 3 kids. I'll say 2/3 go to these children that are healthy, and 1/3 will go into this special needs trust, which is actually a part of my will. And that's not, the worst thing that you can do. However, one of the better options is to do what's called a standalone trust. The trust is a separate document. So I'll say 2/3 to these 2 children, 1/3 to, the James Smith Special Needs Trust. And one of the nice things about doing that is, first, if you do have substantial estate where gifting makes sense, fortunately, that's not a big deal anymore because of the rise of the exemptions. You can make gifts into it during the course of your lifetime. Also, you can allow other people to make bequests into it. So my common example I say is, all right, my wife and I have a child, said Jimmy Smith is his name, and we're setting up a special needs trust because when my wife and I die, we want to make sure that everything that we have gets divided, but the 1/3 is going to go to Jimmy is going to go to his trust to protect his benefits. We could do that through the will. We could do it through that separate trust. The nice thing about the separate trust is, let's say, for example, my parents, they want to leave him $50,000. Well, their will, if they leave $50,000 to him, is going to disqualify him for benefits. Now, on the other hand, they want to leave him some money, but they don't want to spend thousands of dollars of their own to create a special needs trust. It's not the same level of importance for them as it is for me. So the nice thing about the standalone trust is that anybody can leave assets to it. So a lot of times I've seen these trusts set up where mom and dad do it for their children, but grandma and grandpa will leave part of their money directly to trust. So their will say, instead of I leave $50,000 to my grandson Jimmy, it'll be I leave $50,000 to the Jimmy Smith Special Needs Trust.
Okay, that makes sense. I wasn't sure how that all worked, but that makes perfect sense. So if somebody else, because you're always battling that, I suppose, with these is if someone's getting government benefits, is the gifting can cause can cause that to be an issue, obviously.
Yeah, and that's why you want to make sure that anything that is transferred gets transferred in that particular trust. Now, I know we're running out of time, so you don't mind. I'm going to throw one very, very important thing.
Please do, yeah.
And that is, who do you select to be the trustee?
Mm-hmm.
Now, a trustee can be an individual, it can be a corporate entity. And many, many times when we don't have the issue of needs-based benefits and preserving them, I'm very comfortable with families that come in and say, look, I have my adult children. They can take care of being, the executor of the estate or the trustee of any trust I have for, minor children or, grandchildren, et cetera. However, and I'll say in 35 years of practice, I have on no occasion, I think maybe if I did it once, served as a trustee under a special needs trust, because the laws are often changing. And you want to make sure that, because if you make a mistake when you give money out to someone who is, healthy and competent, right, that's kind of an oh shucks moment. I mean, hopefully it's not a big one. But if you make a mistake in the administration of a special needs trust, that person who's carrier entrusted to make sure it's done well, they could lose their SSI and their Medicaid for a great period of time. Mm-hmm. So it's important to make sure that the person, for example, had someone lose their benefits because, and this was actually a corporate institution, which fortunately doesn't do these anymore. And I've seen family members do it. They'll just write checks every month in cash. Well, if you write the check for cash, the person's going to lose their benefits. So get somebody that's good. There are a number of financial institutions that will handle special needs trusts, but if we want to handle somebody you want to hire an institution that is well versed in doing these. There is, for example, in New Jersey, we have Plan New Jersey. They're a nonprofit that they specialize in that. So if I don't get in trouble, I won't mention the other ones that are for profit, but they're geared and they have a specialty in handling these particular situations. Now, people say, well,
that's good advice. Get the experts.
Yeah, get the experts. Well, the one thing you want to do is make sure that you have the protection for the family member. Because sometimes institutions change. Some people are, retire, get replaced by people that are not so nice. Or sometimes you have a great advisor that you deal with who's going to move to another agency. So you can appoint, say, your children as a trust protector. So in the case where I've got 3 kids and 2 are adults who are healthy. I don't want them to be the trustee, but I'll let them be what's called a trust protector. And they have the ability to hire and fire the trustee without any cause. So they can monitor the statements and they can be an advocate without having the responsibility or taking the risks of doing something that they may not be qualified to do.
Okay. All right. A lot to unpack there, but you made it easy to understand. I appreciate that, Tom. And I appreciate you all for joining us on the Estate Blueprint. To learn more or to schedule a consultation with Tom Begley, visit Begley3law.com. That's the number 3 in there. And please like our videos and subscribe to our channel. We love having you be part of our community. Tom, thanks so much for your time as usual. Really appreciate it.
Thanks for having me, Kevin. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.